Hi everyone, it's Wayne Jones, the Course Coordinator for Australian Employment Law. These are my comments and my observations about the reading from this week's textbook, which is Chapter 7 in Stewart's Employment Law Guide. We're talking about remedies for wrongful or unfair termination. If you want to do any additional reading, as usual, have a look at Stewart's other textbook, which is Creighton Stewart, at chapter 19. Interesting chapter because really it follows on nicely from where we were last week, looking at just generally terminating contracts. Although in that week's reading we were also looking generally at how contracts might quite reasonably terminated, and I guess coming from the common law position that the contract is a contract at will, unless the terms of the contract say something else, or unless legislation intervenes. And that's where we're at this week. We're looking at the situation where the allegation is made that the contract has been wrongfully or unfairly terminated. So just as an introduction, some of the terminology is the termination of the contract legal or is it fair? Bearing in mind the old catchphrase of mine that contracts, including employment contracts, are still just contracts, it's entirely possible to apply all of the usual common law rules around contracts to their unlawful termination. In the case of a common law termination of the contract, the employee would say that they were subject to wrongful dismissal. The statutory regime, which has come in the last few years, though, talks about unfair dismissal. So you've got wrongful dismissal where the contract has been breached contrary to law, and you've got statutory unfair dismissal regime that equally needs to be considered. The textbook refers quickly to employers' remedies. Look, we've touched on some of these previously, particularly in the previous chapter. It is a breach to leave the contract, particularly if it's in the middle of a fixed term. So if you've got a contract for 3 years, you just decide to up and leave, then it is technically a breach of the contract by the employee. But what do? Specific performance, not usually likely to be granted because it's usually seen to be against public policy to demand that someone works for a particular person. Sue for damages, possibly, although you have to take into account whether or not the person's going to have the capacity to pay any reasonable award of damages. There is an example given in the textbook, of course, Vision Eye Institute, but I would suggest that's probably pretty rare, where the employer was fairly sure they were going to get their judgment. Ask for a bond, withhold wages, both of those are a bit fraught for the reasons mentioned in the text, but probably again for reasons we've discussed previously. You don't want to leave yourself open to a situation where you're in breach of the legislation requiring you to pay money if there's a step missing. That is, you haven't got a judgment against the employee. Injunctions. Again, textbook refers to those as a possibility. An injunction perhaps not to work for another employer during the currency of the contract, particularly where the employee has got the capacity to find other work. For a couple of good examples, though, look at the two cases which are mentioned in the textbook, Caro and Beyond Productions and Tullett Prebon against Purcell. Just have a look at those as examples of applications for injunctive relief. But principally this week we're interested in the employee's option. So what happens when the contract is wrongfully or unfairly terminated from the employee's perspective? There are going to be a range of ways that the employee can approach this, but the most common are noted here. So you can make a statutory unfair dismissal claim, and you'll see the textbook author refers to the fact that it's quick, but the damages are capped. So you'll see later on we're talking about maybe 6 months worth of pay. So not big payouts, and very rarely would the person get their job back, but the speed is something that I think makes it attractive to litigants. Could go through the ordinary civil courts and make a claim for damages for wrongful dismissal at common law like any other contract. And if there is a connection back to something in the Fair Work Act, remember, it's entirely possible to bring those proceedings in the Federal Court or in the Federal Circuit Court, the old Federal Magistrates Court. Again, costs will be an issue to get the case up and going, but the damages theoretically could take you out to the end of the fixed term, less a few discounts we'll talk about later. Or the other alternative is that the employee may go to the any of the anti-discrimination commissions, the state ones, or to Human Rights Commission, the federal arena, and claim that the reason that they've been dismissed is because of victimisation or because of discrimination. So let's have a look at common law claims. The text reminds us again and again, it's a claim for a breach of contract. So a common law claim for wrongful dismissal is essentially just a claim that a person has breached the terms of the contract. Reinstatement's not likely to be ordered. The reasons given include the fact that courts don't usually want to continue to supervise an order, and realistically, by the time the matter goes to court, remember the person's been out of work, say, for at least 6 months, waiting for their day in court. And because of the case automatic fire sprinklers and Watson we've looked at before, you know that they're not entitled to be paid under the no work, no pay principle. They're accruing, of course, damages. They're accruing the right to collect unpaid, well, it's not unpaid wages, but the assessment of their damages will be the wages they've lost, but they're not entitled to earn anything while this is happening while they're waiting for their day in court. Interlocutory proceedings might assist, but it'll be exceptional. The only example I could think of that isn't mentioned in your textbook is a situation where the company is fairly large, and I'm thinking of an employer like Queensland Rail, for example, although not a national system employer. It may be possible in that case to say, look, in the meantime, put this employee somewhere else while we work out the issue. Do have a look at the case of Baker and Salisbury as an example of a person being reinstated temporarily to allow for a contractual or a statutory process to be completed. So in other words, sometimes the injunction might be you need to go back and complete the process that you promised you'd do before you terminate. Damages, though, much more likely to be what the claimant is after. Contract's well and truly over now. They perhaps have even gone on and located other work, so they're looking for damages. Damages will include their lost wages, superannuation and other entitlements. They might claim for expenses such as relocation costs if they've moved from one place to another, or even if they've been required to move somewhere else to chase additional work. Injury, but it has to be one of those compensable injuries like a psychiatric illness. Generally speaking, no claim for damages for hurt feelings or for humiliation. Lost remuneration, well, essentially means the opportunity to earn their living. It does include superannuation, as I said, but if you've had an allowance to run a car or you've had some other benefits that are not entirely discretionary, they can be thrown into the mix as well. Damage is usually calculated up to the earliest date of termination, and if it's not a fixed term contract, then making allowance for whatever the reasonable notice period would be. So if reasonable notice in the case of an executive is 12 months, then the damages may be for 12 months' pay. Is there a chance that the contract might have been renewed? Well, note the textbook author's comments on that. I think they're validly made, and that is, it is possible to make an argument sometimes that there was, except for such a change of situation, I've had my contract renewed a couple of times. There's a fair chance that it would have been renewed, so I'd like some compensation for that as well. Again, the old point, it is a contract. So just as it is with contracts, the claimant needs to try and mitigate or reduce their loss. So what loss could have been avoided or was avoided? In other words, did they go and get some additional work or even if it was part-time or casual work, that needs to be taken into account. Did that job pay less? Was the position different or inferior? So all that's taken into account in determining the difference, what the person could have earned had the contract continued and what they in fact did earn. Note the comments also about not needing to take up an offer from the former employer to be re-employed. Sometimes the situation's broken down so badly that while that might be useful for the employer to try and reduce their loss, it's quite unreasonable to ask the person to come back. Has it been discounted? Has the claim been discounted to allow for time or for severance that's already been paid? So in other words, if you are looking at a claim, say for 5 years worth of contract, you really will need to heavily discount, probably on the basis of two things. One is that you're having your money in advance, and second, and the courts will normally make an allowance for that. And secondly, that there are all sorts of things that could happen in the meantime. The terminology escapes me at the moment. I think it's something like the vicissitudes of life or something like that. In other words, you may drop dead 3 years into the contract. So just allowing for all of the different things that could actually happen, there's normally a discount of some sort given. Okay, that's the common law situation with respect to an unlawful or a wrongful termination. What about the unfair dismissal claims under the Fair Work Act? Look, have a look at the history, including the comments on evolution of unfair dismissal laws from 17.11 through to 1712. I'm looking now at 17.13, particularly about eligibility and who can bring a claim. Look at section 382 in the Fair Work Act. It provides for these main issues. You've got to have been employed for a minimum period. 6 months is the usual, but if it's a small business, 12 months. Have to have been covered by an award or an enterprise agreement. Or if you're not covered by an award or an enterprise agreement, your earnings have to be less than the high income threshold. That changes all the time, and it's currently in excess of $130,000, but that changes pretty much on a regular and annual basis. In calculating that amount of earnings less than the high income threshold, section 332 says you take into account not only wages but also amounts that are applied to your benefit. Interestingly, not superannuation, but health insurance, union fees, yes, not super. Non-monetary if the parties have agreed to its value. So if you're given a car and both of you agree that the value is $20,000, that could be counted. And certainly not discretionary bonuses. They really can't be calculated, and there's no firm argument that you would or you wouldn't have got them. So the way that Fair Work Commission looks at it is discretionary bonuses are not counted towards that high income threshold. Other exclusions for unfair dismissals: if you're on a fixed term and it comes to an end, fixed task, seasonal, then hard to argue that you've been unfairly dismissed. Probation doesn't affect the minimum period of service. Interesting, and a comment made at towards the end of 17.13 that probationary employees, it's fine, the person may well be on probation, but that doesn't affect the minimum period of service. So that's really only going to come into play when the probationary period is in excess of 6 months. Casuals, no, unless they are in receipt of regular and systematic work, and more about that in a second. Section 384 says that the minimum employment period is determined by reference to the continuous service as defined under section 22, and we've looked at that before in relation to the entitlement to various other benefits. So we know that it excludes certain unpaid leave periods. But if you change your job with the same employer, that doesn't mean that the employment has started and has stopped and restarted. changing jobs with the same employer is fine, there's no break. But if there is a break in employment, if you've been away for a period of time and you return, then that minimum employment period has restarted again. If you served a period as a contractor and then you took up employment, again, that is going to be excluded. So the contractor period is excluded, as was the break in employment. Now, casuals, very interesting situation. And this is probably for the reason that we touched on very early in the course when we looked at the casualisation of the workforce in Australia. Everyone's a casual. We've now got a term of a permanent casual. What a strange idea. So if the person is not truly doing work on an ad hoc basis, if in fact their employment is on a regular and a systematic basis, and they've got a reasonable expectation of continuing employment, even if they've got, particularly where they've got a series of contracts and they're pretty much of a contiguous nature. So in other words, they just ran together, one contract replaced by another, then a casual may be entitled to make a claim for unfair dismissal. So if they had a reasonable expectation and they had been working for more than 6 months, or 12 months if it's a small business, then this might apply. In the case of a transmission of business, not to a related entity, remember that it was up to the person taking over the business to elect. We talked about that last week. The situation was if they're not actually a related entity, if it really is a transfer of a business to a new owner, the new owner can jump in and say, hey, for the purpose of unfair dismissal claims, I'm not going to recognise your prior service. But it has to be in writing and the person has to be told in advance of starting work with the new employer. Look at the situation with small business, probably added very much because of political reasons, but in the case of a small business, Section 383 says the minimum period is going to be 6 months, but it's 12 months if it's a small business employer. And that's defined as somebody who employs 15 employees or less, just on a straight out head count. And associated entities are counted. So it's no good saying, oh, we've only got 10 employees in this branch of our very large firm, because associated entities will be counted. Well, to make such a statutory claim, a couple of things are needed. One is there has to be a dismissal, and that's dismissal on the employer's initiative. It includes constructive dismissal, which we've talked about before, so that is where really I had no other option other than to resign. But that's the sort of test that is going to be applied by the court. They're going to have to see that really there were no other choices other than resignation. Look at the case, or look at the couple of cases which are provided there as examples. One was Australian Hearing and Perry. It was sufficient that the employer's conduct had left the employee with no reasonable choice but to resign. But see also Davidson against the Commonwealth. In this case, the senior public servant, suspended pending an investigation into alleged misconduct, couldn't really claim that there was nowhere else to go, had to resign, because of course the person could have waited the outcome of the hearing. So there has to really have to be no other options. Specific period or casual, not if it's a substantial purpose or of why they were engaged that way. So if there's a good argument that can be made that an employer has put somebody on for a specific period or as a casual purely to avoid unfair dismissal claims, then they won't. Section 386.3 will draw them back in. Casuals, of course, when we looked at a case previously called Thompson against Big Bert, if there's simply not offered any further work, that's not enough to ground a claim. But if they've been regular and systemic for the last 12 months, and there's no real evidence of limiting the terms hiring, so there haven't been other examples, or this person hasn't suffered examples where they've had work and then they've had no work for a few months and then back on again, then it may well be a dismissal. It can also be a dismissal if a person is moved into another position with a significant reduction in salary. Now, to avoid dealing with multiple claims at the same time, it's not possible for an applicant to apply for unfair dismissal remedies if there are other proceedings on the go at the same time. So if an application's been made under another section, and the good example that was given in the text was the one regarding general protections, which we looked at previously. If there's a general protections application on the go, then the applicant can't proceed with an unfair dismissal claim. But if there is a claim out there that relates to, for example, a sexual harassment claim that was on foot, it related to pre-termination conduct, there's no reason it can't continue. Now, initiating proceedings, the drop-dead date is 21 days. There is a discretion, but don't count on it. The word used is exceptional circumstances. Examples that have been allowed in the past have been lawyers or union failing to lodge on time, but just being ignorant of the time limit is not enough. Everybody seems to know it's pretty short. It's 21 days from the dismissal date. The procedures are in 396. There's usually a pre-merits hearing, so that might even be done on the papers, where the Fair Work Commission determines whether the application's been made within time, is the applicant an eligible person, so are they eligible to make the claim, has the Small Business Fair Dismissal Code been complied with, and you'll see in a moment that if it has, then that precludes making a claim, or is it in fact a genuine redundancy? So they're the preliminary factors that are looked at on the papers to see whether Fair Work will even take the claim. The pre-merit hearing, some of the examples of why, or some of the examples that might be thrown up by the respondent would be these: denying that it is in fact the employer, claiming that the person was in fact an independent contractor, claiming that there was no real dismissal, so the person worked away from the job, just walked away, I should say, from the job without any reason. They hadn't served the minimum period required, or they were a high-income employee. But after that's been got through, the procedures then continue. So the Fair Work Act 399 capital A will also ask the Commission to look at whether the parties have been unreasonable thus far. So if they fail to attend conferences or hearings, or comply with directions, or even to discontinue a claim after one of them maintains quite reasonably that it's been settled. Section 587 also says that the Commission can take note of, or can dismiss, I should say, a frivolous or vexatious claim that has no prospect of success. Now, the procedures. There's a considerable amount of flexibility in hearing and determining the claims. Generally, they will head towards a conference first, but can move directly to a hearing if that's warranted. In some cases, I see the textbook mentions that it is possible to have no hearing in the case of no disputed facts, and I presume in that case what they mean is that the Fair Work Commission is simply being asked to make an order, either to reinstate or to determine the appropriate amount of damages. The decisions technically can be appealed, so remember they're from a single commissioner. They can go from there to the full bench, but really has to have a matter of public interest. And that's quite a difficult thing to show. It needs to be an important issue of principle that needs airing, manifest injustice, significant errors of fact. So plenty of applications for rehearing, but very few proceed to the full bench. Well, what needs to be proven to make such a claim under Section 385 of the Fair Work Act? Well, they need to prove that the dismissal was harsh or unjust or unreasonable. It was made inconsistently with the Small Business Fair Dismissal Guide, if that applies. So they hadn't followed the rules set out in the Small Business Guide. And it was not, in fact, a case of a genuine redundancy. The Act in Section 387 tells the Commission to take into account these things: Was there a valid reason related to capacity or conduct? Was the employee notified of the reason with an opportunity to respond? Were they given warnings? Note that they don't necessarily need to be in writing, but they may want to be able to produce the fact of the warnings somehow. Remember to meet the Small Business Fair Dismissal Code. That the person had an opportunity to have a support person present when they were being told that dismissal was a possibility. The Commission also takes into account the size of the employer and the access it had to good HR advice, particularly when there's a complaint made about process or the employer really not sticking strictly to the rules, say, of the enterprise agreement. Something of a technical nature, the Commission can take into account the size of the employer and their access to advice, together with any other matter that they think is relevant. Valid reasons are sound, defensible, well-founded. They're not capricious, fanciful, spiteful or prejudiced. Notifications and warnings refer really to procedural fairness, an opportunity to address poor performance or to answer allegations. And have a look at, we've referred previously to Byrne and Australian Airlines. Just remember all the time that process failures are not enough, that the Fair Work Commission will look at the circumstances as a whole, and they can rely on, the employer can rely on information which came to light later. But the big issue there in that Byrne and Australian Airlines case was absolute, strict and slavish compliance with the processes that are called for in an enterprise agreement are not always required. There'd have to be a real breakdown before I suspect the Commission would find that even in the face of the sort of behaviour that we saw in Byrne, where they were pilfering from the luggage of customers, that would override the facts of the case. Now, some of the examples that were given in the text, look, have a look at the cases which interest you. There are quite a few there, and I think it'd probably be worth scanning through a few of them just to get a feel for. You'll see that there's at 17.20 at the beginning, there's a quick rundown on the sorts of things that seem to be common threads. So policy not properly communicated to the workforce, or policy not applied consistently. And remember we talked about that previously with the Woolworths case and the dress code. If you don't really apply it consistently, then there's a good reason why someone might not be complying with it. Not properly investigating a matter, failing to take into account the length of service and previous good record of an employee. But do think about looking through some of those cases at 17.20 just for more in-depth feeling for them. We mentioned a couple of times now that Small Business Fair Dismissal Code. By all means, have a look at it. Compliance with the code and the checklist simply means that there's a fair chance it will amount to a complete defence, that the unfair dismissal claim will have to be rejected. It's always going to be a question of degree, of course, as to whether they did comply fully, but these are the things they need to do. It has to be those reasonable grounds we talked about before, serious misconduct, etc. And there was a suggestion that if it's reported to the police, then it's pretty well going to be accepted. Warnings given and a chance to rectify. Was there a support person present? And now can the small business produce written evidence or objective evidence, including statements if necessary, to show that they've done all those things? And if they can do that, then that is a defence. And of course the other defence was genuine redundancy. We've spoken about redundancy previously. You can't make an unfair dismissal claim if in fact you've lost your position because of a genuine redundancy. Remember from previous discussions, section 389 says the employer no longer wants the job to be performed by anyone. So it's performing the job or the disappearance of the position. So once that position is gone, then, and it might be because of a variety of reasons. Remember we talked about those. Could be a restructuring of how the business is going to be operated. Could be financial reasons. But whenever that's proven, then you can't have an unfair dismissal. So obviously enough, that's one of the most often used defences by employers, that it was not a dismissal but a redundancy. However, Section 389 says that the employer can't rely on that until it complies with the award or the enterprise agreement requirements to consult, or if it's allowed for in the award or the agreement, a reasonable chance to talk about redeployment within the business or within the related entities. So that might mean offering employment with a related company. But once these are met, then all other bets are off. So you don't go back to talking just generally about the fairness of the dismissal. It's not like raising redundancy opens up all the other matters. Once those couple of requirements are met, then all other aspects of the dismissal are irrelevant. Reinstatement gets a mention at Section 390. So the damages or compensation are available if reinstatement is inappropriate, is the wording used. If a person is reinstated, then the continuity of their service is preserved, but it can be really difficult if the working relationship's absolutely broken down. And probably there's a fair argument that the smaller the firm, the more unlikely it is that reinstatement is going to happen. It can be very hard for managers or supervisors to be reinstated back to their old position. But a comment that I make, again, that I made earlier that I don't necessarily see brought out in the text is that I think the size of the employer also matters. So I have seen good arguments put up in the past with the Commission where an employer was very large and an employee wouldn't necessarily need to go back into the same workplace that they were in before. They could in fact be moved somewhere else within the organisation to do useful work. And I think that's an argument that needs to be raised. So far as remedies are concerned, look at the case of Sprigg and Paul's, which is mentioned at the bottom of 17.23 in the textbook, for a formula of sorts as to how damages are calculated. So the Commission will look at the remuneration that the employee would have expected to have earned between when they were put off and the date of the hearing, or what was or the date of a reasonable period of notice, less any payments that have already been received. So if they've been treated as a redundancy, they may have already received substantial payments. Less any amounts earned, so if they have got out and earned some income in the meantime, that'll be taken off, or amounts that they could reasonably have earned if that argument gets up and works. But if it's still a relatively short period, that might be negligible. And then that discount for contingencies that I mentioned earlier, so the person receiving their money in advance and the fact that lots of other things could have happened along the way, and that equals the payout amount. Now, that's obviously fairly flexible, but that's the sort of arguments that you'll need to put up when you're making a claim. There is a cap to compensation. Remember, that was the payoff for this being a fairly fast process, was that compensation would be capped, and it is capped at 6 months or half of whatever the high income threshold is at that time. Still requires those calculations that we talked about a moment ago in Sprigg and Paul's, but so it's not actually a maximum damages payout. You don't make an application, for example, for 6 months' pay. You make an application based on addressing those Sprigg and Paul's factors. So just to come back to that again for a moment, you may say, well, look, discounting and the prospect of other employment simply shouldn't be counted in this case because, and then whatever the argument is, therefore we'd ask for the maximum payment. But you can't just jump straight to that point. And just as a matter of interest, as at today's date, I had a look, it's the half of 136,700, so it's 68,350 would be the cap. So still a substantial amount where the person has received other amounts, say as redundancy or accrued entitlements. Cost orders are unusual, but should not be discounted, definitely should not be discounted. So your starting point is, well, not usually made, the orders aren't usually made, But section 611.2 says if someone makes a claim, and this includes defends a claim, for reasons that are vexatious or without reasonable prospects of success, costs can be ordered. Section 400A, Section 400A says that the Commission can take into account unreasonable acts or omissions of the other party. And I think that what they're getting at there are actions that are taken after the merits have been assessed by the Fair Work Commission in the first instance. So just say the parties attended a conference and there was a pretty clear indication at the conference that either reinstatement or compensation should be paid. Then in that case, if the employer was to press on, I think you'd make an argument under Section 400A that they'd been unreasonable, that they just simply failed to take any notice of what they were hearing from the Commission, and now we're a couple of months down the track at a hearing. So always worth the argument. They're my comments for this week. Next week we'll talk about health and safety and industrial action, but I hope you enjoyed that reading on the issue of remedies for wrongful or unfair termination.